All right, let's talk about data protection. The Data Protection Bill, which first got life in 2018, was tabled in 2019, then referred to a joint parliamentary committee whose members also changed, got several extensions, will finally perhaps see the light of day in this winter session of Parliament. Now, while all the focus has been on cryptocurrencies and what happens to cryptocurrencies, the fact of the matter is a very, very small percentage of our population even trades in cryptocurrencies, while the Data Protection Bill is going to impact pretty much everyone. It's safe to say a large majority of our population right now has their data out there in some form or the other. There are multiple agencies collecting our personal, non-personal data at any given time, and right now we just don't have the laws to govern how this is being used. The funniest and strangest and actually saddest part of it all is that the consent of the individual seems to have gotten lost in this whole conversation. So the idea behind the Data Protection Bill was to have laws which are in tune with current technology and replace outdated laws that exist. Also, at the heart of its intention, at least, was to protect the individual user from their data being misused. Does the current draft bill achieve those objectives? That really is the question. Let me go across to our panelists today. I have Apar Gupta, Arvind Gupta, and Nikhil Pahwa on the show today. Welcome to all of you and thank you so much for joining us. Apar, let me begin by getting your take, since this is a subject so close to your heart. We know that the JPC has come back with its recommendations on the bill. 7 MPs have objected to what the JPC has come back with because they think that the government will exert too much control over data. Do you think that is the primary concern you have today when you look at this data protection bill, and does it actually protect individual data?
Thank you, Tamanna. The problems with the data protection bill actually are not towards satisfaction of sufficient levels of protection, not only in the process of what the JPC has done or what the government has proposed, but from its very inception when the Sri Krishna committee was constituted. Because, quite often people in the general public have this misconception that the data protection bill will also be a form of surveillance reform. It will take care of instances which have been in the press, such as Pegasus. It clearly does not do that. And we've not had any surveillance reform. The second issue with the data protection bill as of now, and let me also say the copy of the JPC report is not yet public, it's privileged. So I cannot comment on its specific aspects. I'm going by press reports. Is essentially that it's seeking to carve out large government exemptions on 2 grounds. One, if it's necessary for the government to obtain data without any consent, it can do it under the condition of necessity. Here, Mr. Jairam Ramesh has published his dissent note on Twitter, and he said it should also be proportionate. The second is that the government can notify a department from exemption of the application of the complete law. So you may have a situation in which the UIDAI, which is the regulator of Aadhaar, may be exempted from the application of data protection law. So I'll just pause here, but there's a large degree of dissatisfaction. But I think any law on data protection will go through a process of incremental improvement over a passage of time, because it's also made in the context of the Puttaswamy, the Supreme Court judgment. So we'll see incremental improvements through a process of judicial challenges and amendments in years to come. I'll pause here.
Yeah. Nikhil, let's begin with the basic question. So one concern obviously is that has the central government given itself too much leeway in terms of exemption? So can it access people's data without their consent? As far as what we know of the draft bill, yes, it can. Can it exempt central government agencies from having to adhere to the rules? Yes, it can, and the reasons for it are safety, security, national security, etc. So that is one concern. But at the heart of it, it is also about giving control to individuals about how their data is used. Do you think it's at least doing that?
Tamanna, I just want to comment a little bit more about, the government access to data first, because let's not forget that the entire genesis of the data protection bill was with the Aadhaar challenge in the Supreme Court, after which there was a ruling on the fundamental right to privacy. And the basis of all of this was basically about government collection of data. So the very fact that this data protection bill most likely, reduces oversight or doesn't provide sufficient oversight, doesn't provide sufficient proportionality over government collection of data, kind of defeats the purpose of the bill to quite an extent. That being said, of course, we have seen that there are, global MNCs that have, and also local companies that are collecting far more data about users than they should be, or than they even need to. Quite often, companies collect data that has nothing to do with the service that they're providing. So, standard clauses, which basically means that there has to be a purpose to the data collection, which needs to be specified, and it needs to be proportionate to the utility of that data for the provision of the service. Those kind of clauses really help protect users or give them rights. Um, Apart from that, I would say, just going back to important aspects of the bill, one of the things that I'm most keen on is the independence of the Data Protection Authority. Because if there is far too much central government control over or any kind of government control over, the appointments of the Data Protection Authority, of the ability for the central government to perhaps override or exempt entities from the purview of the Data Protection Authority, then it will defeat the purpose of the bill. I mean, I had the privilege of having a long conversation with the chief uh, privacy commissioner of the Philippines a month ago, and he was very like the first thing that they had done was that
Yeah.
they sued the chief election commissioner's office in the Philippines because of a vast amount of leakage of data, and he was very, very clear that they had to identify a big case and take the bull by the horns to make an example, to make sure that people understand that their rights are going to be protected. Can such a thing happen in India under this law? It looks very, very unlikely. And let's not forget that historically, the UIDAI and government departments have published all sorts of Aadhaar related data on the internet. Yet none of them have been actually taken to task for leaking our
Yes.
personal information, which makes us very, very vulnerable. So, like I said, if there isn't increased accountability of the government, if there isn't increased independence of the DPA, this bill is not likely to help users, except when it comes to data collection by private companies, which also needs to be kept in check.
Yes. So I will come to the question of data collection by private companies, why private companies right now are nervous about what's going to be in the bill, why social media intermediaries are nervous about what's going to be in the bill. So I'll come to that. But I want to get Arvind as well in on the aspect of government access to data. And that really is at the heart of it, isn't it? Are there enough checks and balances that a government can't access your data and possibly use it against you without some kind of oversight?
So, Tamanna, first of all, let's agree that this is a forward-looking bill. It is a bill which is, India has, looked forward to for such a long time now. I think on your channel we've debated it many times that this is something that we really look forward to. I hope it passes in this session of the Parliament, and I'll come and address your question about government and private entities. But the biggest thing is that I think both Apar and Nikhil have agreed upon is that it's important to get this bill to make sure that what we have in our pockets, our smartphones, our connected devices, that data without purpose is not being connected and without consent is not being collected by this large international companies, by platforms, by anybody, and being misused for advertising, for lending, for all the other things that we are seeing. Now, coming to your part, on the current form and the discussions that have happened in the JPC, we've seen some informal comments or on Twitter or some media reports, and there are I mean, and they'll from here till actually the bill when it gets passed in both the houses, there'll be changes, there'll be amendments that will be made. So we don't know where it finally is going to end up. But on your question about the government, see, as far as I understand, the intent of this bill has been the individual really owns the data. It's a data empowerment and protection architecture, and only in certain exceptions, which are granted also by the Supreme Court, then with actually now oversight, which is what Nikhil and Apar are also kind of raising a question, but actually saying when we have an authority and it has powers with kind of oversight, if the data can only be shared by the government only in those exceptions. There are other, forms where.
Sorry. Arvind, let me understand this correctly. Sorry, let me understand this correctly. I'm sorry. I think we're just meandering a bit. So you're saying that we should not be worried because there is a data protection authority that will have oversight over when the government wants to bypass the rules and access data without consent or exempt its agencies. Is that the point you're making?
Yes, I'm saying that. That if there is a mechanism where it is properly, if at all it is requested by the government, and then there is a request, like the government is taking a request for a particular set of data, which is there, the Section 12 exemptions, then at least the DPA is in the loop. Now, the point I'm trying to make here is that without seeing the actual final form,
but just rejoinder, just a second, quick rejoinder. Isn't the central government pretty much in charge of who is on that DPA?
Yes.
They're government officers who will decide the composition of that DPA, isn't it?
But doesn't that apply to every constitutional authority? Doesn't the government also decide who is the Chief Election Commissioner of India? So it is.
But this is not a constitutional authority, Arvind.
No, not a constitutional authority.
It should be a constitutional authority.
We'll see what form it takes. But I'm not saying it's. I'm not saying it's a constitutional authority. But I'm saying, doesn't the government also appoint a CEC or an election commission? So that point does not work. That just because the government appoints somebody, it loses its validity and its authority. So I don't see a reason to be worried yet.
Autonomy is the question. Yes.
Yeah, the autonomy. It's a separate body. It will be autonomous. And that's the intent of it. It has the expertise to regulate. It will have the expertise to fine and to govern the whole space. And it should be governed by the right set of people. So that's the key. The right set of people is the key. For a good regulator to work, it has to be the right set of people.
Okay, so independence of a regulator is always, the core to implementation of any tricky piece of legislation. Let me come to the second part of it, which is what this means for others. We've talked about what it means for government. What does it mean for others in terms of other entities? And Apar, let me come back to you on that. Now, private companies in India, global private companies, and social media platforms. Now, these are 2 or 3 segments of, I would say, companies who would be impacted. How do you think this bill works out for them? Because they now have larger responsibilities as well as more stringent rules governing how they use data of users.
Thanks, Tamanna. I'll take this question in 2 parts. And the first is essentially how a data protection law such as this also applies to all companies. Companies used to look at it from the perspective essentially of operational practices and compliance, and in terms of what it impacts their budget. But they need to also look at it from the perspective of user trust and building a better relationship with any person from whom they collect their data. Quite often, even business activities which are not purely in the technology sector now rely on getting a large amount of user data. And I think this is useful also because it brings a level of regulation to the collection of data, will bring safeguards. For instance, if a company is storing a person's data, they will also personally provide notice and put that person to knowledge they're collecting that data. They'll also put that person to knowledge what was the purpose towards that data will be used, and after that purpose is met, they will need to delete it. They will need to also secure it till they're using that data. There'll be a vast array of rights which will be existing. For instance, people can also ask a company, are you storing my data? What data are you storing? How are you keeping it safe? All of these things will come into place. Now, this shouldn't scare companies because the level of compliance will also depend on the industry sector they work in, which defines the sensitivity of the data. Let's imagine if it's financial or medical data, it will, of course, have a higher degree of protection. And secondly, it will be dependent on the business threshold of the entity. How big are you? How complex are your systems? How much can you implement? Finally, I'd just like to end this by saying that there's another second part to what has emerged from press reports, which does deserve some amount of attention. It's the regulation or the treatment of social media entities as publishers, which is concerning to me because any data protection law, I would say any, and I can say this with confidence all over the world, does not treat social media companies as publishers. And for a data protection law to do it is, for the lack of any formal word, I would just say it's weird.
Yeah. Let me talk to you, Nikhil, about what it means for the social media platforms and why they are a concern a lot today. It also, in a sense, makes them responsible for what is being said on the platform. Is that a big concern?
So those are intermediary liability related questions, Tamanna, and I think, frankly, social media platforms should not be held accountable for what is being said on the platform because they will never survive that liability. No social media, if I was a social media platform and such a clause were to come in the PDP bill, I would actually go to court to try and stop it because my entire survival would be at stake. That being said, let's not forget that there are two entities in particular because of which we have a strong move globally on data protection. Firstly, what really started this is the advertising ecosystem. There is globally ad networks, ad agencies, audience targeting networks have basically collected far too much data, have bought data from data brokers, illegal data collection to target us in various ways. Social networks, especially Facebook, took this to another level where they collect so much data on us that they're able to granularly target us. That has led to harms not just to individuals, but also to
Yeah.
democracies. So, therefore, bringing in restrictions, especially purpose limitation, transparency for users about what data is collected about them, has been essential not just in India but the world over. And I'm glad that these restrictions are coming in. That does not mean that they should be treated like publishers. So they're two different things. But if I was an advertiser in the advertising business, in the digital
Yeah.
advertising business,
Yeah.
I would be very, very worried right now because while social media companies are fully aware of what's going on, frankly, most of the advertising ecosystem in India, to my mind, is largely ignorant about it. Um, we also have to keep in mind that one key aspect
Well,
that might come into place with this bill is that of data localization, and that to me actually harms the global nature of the internet. I know that Europe has done this to quite an extent. Other countries have also considered it, but what it means is a form of fragmentation of the internet, which means that there might be some services which we may not be able to access here in India because those services may choose not to localize their data in India, and so they might not choose to serve our market. I think we need to move to a situation where the global agreements on data protection, where there are laws that protect users equally across the globe. Very hard to do, but at the core of it, all of us have grown up with the global internet. I think we should be very, very careful
we need
about
to
how
make
this
a start.
legislation impacts the global internet. Yeah.
Yeah. Absolutely. I'm short of time, but I want to come to you, Arvind, on the liabilities for social media giants and how that will move forward.
See, that is, I mean, there is already the liability angle, the guidelines, things that have already been defined in February of this year. There is liability on data collection and usage. when you put social media giants and paint them under in one brush, I think, as Nikhil has already said, this is where we can agree. They should be concerned, because they cannot take our data for granted and use it for whatever purpose of targeting us indiscriminately. So I think it's good. It's that India is showing the right path on this, and there is a and it will evolve. And I disagree with Nikhil on one ground, that we'll create a data splinter net in that sense, and people will choose not to localize data. If there is a need, people will do it. India is a big enough market. Every company has shown some resistance initially, but finally they have come around. India presents itself 800 million internet users, 80 crore plus internet users. No company is going to leave. No platform is going to leave India.
But that's
Because
only the large platforms, Arvind. The thing is that there are many small startups.
They will all figure out. They will all figure it out. They figured out GDPR. We've seen a lot of resistance initially. So, if you have to do business in India, eventually you have to follow the laws.
Yes, but we can have laws that don't necessarily harm the global nature of
and data localization is an
we're
ask of several countries. Data localization is an ask of several countries, not just India. We will have to wait and see, gentlemen. We'll have to wait and see what the actual bill looks like when it is tabled in Parliament. But suffice to say that it is going to be one of extreme import on how we all behave as internet citizens and how our data is used. One can only hope at the end of it that it truly protects the individual's data, the individual's information, not just from fraud, but also from misuse for commercial purposes. Well, on that note, I want to thank all of you for joining us on the chat today.